You may proceed.
Thank you, Your Honor. As the court can see, Mr. De La Rosa is an amputee, in which he suffered from injury a few years ago. Your Honor, we're requesting if the court would consider probation. I believe that Mr. De La Rosa would benefit from being on a mental health caseload as well. He does suffer from some mental issues that I feel that would be beneficial if he could receive care through either MHMR or Spindletop. He understands that he does have prior convictions, so as a convicted felon, he cannot possess a firearm. And he understands that moving forward, no matter what situation he's in, he cannot have a firearm. Your Honor, he does have 2 children that he would like to be better involved in their lives. One of the main issues that I see in the PSI is education. He has a 6th grade education. I think it would also benefit if he would be allowed and participate in the GED program through the probation department as well, to help him to develop some skills so that he can make better decisions and get his high school, at least minimum high school equivalency. There isn't much history in regards to substance. With regards to substance abuse, looks like maybe alcohol that he drinks on occasion. And he has no problem, it says, in his recommendations to avoid any association with the co-defendant, Ashley Faye. And as I stated, Your Honor, he would be willing to adhere to any referrals or treatment plans or directives that probation may recommend. And so we are requesting probation.
Thank you, ma'am. Mr. Nichols.
Your Honor, he has 3 prior felony convictions, 1 for being a felon in possession of a firearm, 1 for aggravated assault with deadly weapon. He should have been habitual. I took into consideration his health issues when I made the offer of an 8-year cap. I don't know that he deserves any more consideration for what has happened to him. You see his gang history, his criminal history. I think 8 years is appropriate in this case.
And I'm sorry,
Mr. De La Rosa, you wanted to say something?
I do got priors now, but I don't know like juvenile stuff like that.
So in 2015, you were not a juvenile.
2015 was that when that conviction was like I think 7 years.
That was your conviction for unlawful possession of a firearm by a felon. And you got a 2-year sentence.
Yeah, no, but I did my time and I did parole. I did good behavior.
Right. So you should have learned. Not that you can't possess a firearm. I mean, and Ms. Holmes is doing the best she can, saying that, you know, you understand and that you can't possess a firearm, but you've already gone to prison for that. So
I was at the wrong place, wrong time. Now, I mean, it wasn't my position due to the fact that I am a felon. I'm not denying it, but you know, I would deserve I feel like a second chance or something.
well,
I always keep like I want to get thrown in prison, come out when I'm 38, something like that.
well, and I understand. Well, and here's the thing, Mr. De La Rosa, nobody wants to get thrown in prison. And what I do today isn't anything that I'm doing. It's where you've gotten yourself with your history since you've been a juvenile into being an adult, knowing that you cannot possess a firearm. You've got 3 prior felony offenses. 1 was when you were certified as a juvenile, that first one. And then if you didn't understand the law about deadly weapons, you should have, or carrying a firearm, you should have back in 2015. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. I'm going to sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement I followed, so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, we know this now. I'm required by law to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. right, good luck to you, sir. You can go back with the bailiff. Badreldine Al-Haroni.
Yes, Your Honor.
I highly doubt that I said that correctly, but I
The last name
tried.
was good.
The last name was?
The last name's good.
Good morning, sir. How do you say your first name?
Badreddin.
Okay. Mr. Al-Haroni?
That's why I said the last name.
Yeah, so Mr. Al-Haroni is charged with possession of child pornography in cause number 25 DCCR 1378. And what is the announcement?
The prosecutor and I have met about the case. We spoke last week and we spoke again this morning. There, I don't know if you want to speak to, there's some issues with the indictment. One, but the other are, since she has taken over the case, we're kind of discussing a resolution.
So I see that there was a motion to quash the indictment that was filed some time ago, back in December. What I can do is just reset it, Ms. French, since you're just getting on the case, give you some time to look at that indictment. If something needs to be amended, you can take care of that. If you think it's fine, then we'll have the hearing on the motion to quash at the next court date. And, or if you guys come up with some agreement, we can take care of that. But I'll just do a normal reset so you guys can look more into it.
And
And
she's
then-
jumped into it pretty fast. We've had some really good.
Yeah,
pretty good
no, I have no doubt she has. She's jumped into them. So we'll do a normal reset. Stay in touch with Mr. Rennick so that once he gets any information, offers, things like that from the assistant district attorney, then you can visit with him and we'll see if we can get a resolution.
Thank
Okay,
you,
you're
Judge.
free to go. Thank you.
Thank you, Your Honor.
Morning.
Good morning. Morning. All right, sir, you diving, Kalina?
Yes, ma'am.
This is 24 DCCR 2432. Mr. Kalina is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
Judge, I think we're on the goal line to a resolution. The court would allow the last reset.
Any issue?
Judge, Mr. Cat was on this for quite some time.
Yeah, I
So
see that
Mr.
there was-
Kelly has been on a shorter period of time. We're not quite there yet. We've kind of countered a couple different things, made a few phone calls, but we're doing our best.
Thank you. I'll just do a normal reset. This, I know you haven't been on it very long, but this will be the last reset just because the case is getting long in the nature of the offense. And
Understood.
so make sure, Mr. Kalina, that you stay with Mr. Get in touch.
This is a huge break. The defendant is walking away without a felony conviction for now. But there's a catch. One serious probation violation could bring her right back into this courtroom, where she could face up to 20 years in prison. It's a second chance, but one that comes with very little room for error. If you were in this situation, would you see probation as an opportunity or a warning?
And visit with Mr. Kelly before that next court date. Once he gets any final offers from the state, you guys can go over that and we'll get an actual announcement at that next court date. Okay,
Thank you, Judge. Thank you.
Mr. Kimler, I was holding on Raphael Glover.
Ready.
Right, sir, you're Raphael Glover. And Mr. Glover's case is set for trial to begin with jury selection next Monday and cause number 24 DCCR 0232. And what is the announcement?
Your Honor, the state had tendered a new offer today of 10/10. Mr. Glover's informing that he's refusing that. We're still requesting a trial.
Great. Any
State's
issues?
ready for trial, Judge. We're ready.
All right, so Mr. Glover, I'm going to number the case for trial. Your case is very old. It's likely to be somewhere near the top of the list. After today, I will not accept this agreement. So you have every right, obviously, to have a jury determine if you're guilty or not. If they find you guilty, what your punishment is. But after today, we're not going to come back and do a probation tomorrow or Monday afternoon at the last minute. Today's the day for that, okay? All right, stay in touch with Mr. Kimler and your bondsman, and we'll see you back next Monday at 1 o'clock. Okay?